A mob of people, including people holding senior positions as state officers, invaded the dais at the National Tallying Center of the presidential election at the Bomas of Kenya. In what I regard as a very, very orchestrated and clear attempt to interfere with the powers of the IBC to declare the presidential results following the verification and tallying of those results. As a result, chaos erupted. Several IBC commissioners, staff, and other people who were lawfully at the tallying center were seriously injured. To date, nobody has been asked even to write a statement on what happened on that day. Today, no investigations whatsoever have been made by the agencies of state which should be doing this. And to date, this heinous and frontal attack on our democracy remains unresolved, and the perpetrators are marauding around the country, and some of them are in this courtroom. Chief Justice, judges of the Supreme Court, the events on that fateful day mirror what, in our respectful view, took place on January 6, 2021, when a rowdy gang of violent protesters laid siege on Capitol building in Washington, D.C., in the United States of America, following the spectacular defeat of Donald Trump as president of that country in the 2020 election. The chronology of events of that day, the day our country was shamed in the eyes and in the presence of diplomats from all over the world, local and international press. The events are detailed in the affidavit of Mr. Wafula Chebukati, a gallant son of Kenya. That affidavit is before this court and is dated 26th August 2022, particularly paragraphs 58 to 75. This has been corroborated, my lords, my ladies, by the affidavit of Professor Abdi Gulie and Boya Mulu, the affidavit of Boya Mulu, both of which are before this court, and the relevant parts are paragraphs 17 to 37 and paragraphs 9 to 10, respectively. We respectively submit that the aforesaid activities at the National Tallying Center on 15th of August 2022, regrettably perpetuated by emissaries, agents, supporters, and sympathizers of the first petitioner, who is now before this court seeking redress. Those events and those activities amount to nothing short of a flagrant attempt to overthrow the constitution of our country, to subvert the sovereign will of the people of Kenya, contrary to Article 1 of the Constitution. It is our view that those events alone constitute nothing but an attempt to establish a government unconstitutionally, contrary to Article 3(2) of the Constitution. And in our humble and respectful view, Chief Justice, my lords, my ladies, the events of that day are basically an attempted but failed coup d'etat. Unfortunately, The jurisdiction of this court under Article 140 does not allow it to punish these egregious acts of treason, but these events must inform the context in which the main petition and its offshoots ought to be adjudged. Curiously, the mentioned public officers, who include civilian state officers, including a cabinet secretary, senior military officials, including the Vice Chief of Defense Forces, head of police, head of intelligence, the head of public service and chief of staff, which is itself is an illegal position under our constitution. All those people have not denied that they met the IEBC in plenary. The only thing they have told this court is that they went there to try and fast track the declaration of results and not to do what Mr. Chebukati has told this court on oath, which is they went to go and try to have the first petitioner declared as president of the Republic, or otherwise force a runoff between him and my client. With tremendous respect, we ask this court to consider those acts as not only destructive to the independence of our institutions, but more particularly an affront on Article 249, 2A of the Constitution that describes the IBC and other such independent institutions in the following words, that they are independent, and I quote, and are not subject to direction or control of any person or authority. That includes, in our humble view, positive and negative interference, even if, for argument's sake, which is denied, those heads of very sensitive institutions walked into a plenary of the IBC to fast track the declaration of results. Even that in itself is illegal and unconstitutional. What are the principles upon which the context we have laid should be adjudicated? Chief Justice, members of the Supreme Court, it is the submission of the first respondent that there are at least three immutable principles that run across most Commonwealth jurisdictions upon which this petition and its offshoots should be adjudged. One is the principle that no election shall be questioned or declared void because of errors, informalities, irregularities, or illegalities that have little or no bearing to the process and the result. This principle, Chief Justice, judges of the Supreme Court, this principle has endured for more than 150 years and was first initiated in the United Kingdom Ballot Act of 1872, Section 13. 2, that the burden of proof in election petitions lies on the person who seeks judicial invalidation of the election, not on the respondents. This principle has been cited in one of the authorities we have relied in and already highlighted by learned counsel's senior counsel Fred Ngatia, the case of John Mahama versus the Electoral Commission of the Republic of Ghana, 2021. Principle number 3, and this is specific to Kenya and the minor KI decision. The polling station is the true locus for the free exercise of the voters' will. And I'm shocked to see the petitioner and the latest pseudo petitioner, because when I listened to the Attorney General with due respect, I clearly thought that we are listening to another petition, especially on the issue of Article 138(3)(c), despite the assurances that he was not opposed to any petition, and I think he fell short of saying he's supporting the petitions. What are the specific principles in the interest of time? The first one, those are the 3 are the general principles. What are the specific principles? 1, and what I intend to demonstrate with these specific principles and the general principles is that the answer to the question on the issue number 5 is in the affirmative. That yes, the IBC carried out verification, tallying, declaration of results in compliance with 138(3)(c) and 138(10). These are the reasons. Number 1, the verification and tallying happened and was done by the chairperson, commissioners of IBC and the staff at the National Tallying Center in the presence of the candidates of the agents of the presidential candidates. And this is in the affidavit of William Ruto, paragraphs in support or in opposition of the petition, paragraphs 18 to 20, and the affidavits of Veronica Nduati, paragraphs 7 to 14. Number 2, the IBC complied because an interpretation to the effect that Article 138(3)(c) refers to the 7 commissioners, or a majority of them, is inaccurate and pedantic for this reason, that the Constitution and the Elections Act attributes to the Commission certain acts that are eventually done not by commissioners, but by both the permanent and temporary staff of the IBC at the polling station, at the constituency returning the constituency tallying center and county tallying center, and I dare say even at the national tallying center. And that explains why, for example, the Constitution in Article 86(5) and 86(b) and 86(c) talks about the commission, but the work eventually is done by returning officers and in the first instance by the presiding officers. C, B, and C of Article 86 of the Constitution, which is not speaking about the National Assembly election or any other election, but the presidential election. The actions of returning officers, presiding officers, are deemed to have been done by the Commission, and that explains our argument. Number 3, an interpretation to the effect that Article 138(3)(c) refers to the 7 commissioners would lead to an absurdity in interpretation, because it is not humanly possible for the 7 men and women who are commissioners, however important they think they are, it is not humanly possible for them to tally results emanating from 46,229 polling stations across the country at the moment. Number 4, verification, tallying, and declaration was done because the right to franchise, Chief Justice, judges of the Supreme Court, this right in Article 38 of the Constitution cannot be subjected to the will, to the veto, or even to the ego of 7 men and 7 women. Even if, as they claim, they think they hold the constitutional veto to try and moderate or alter or balance the will of the people as expressed at the polling station and has received in original 39 A's. Number 5, verification, tallying, and declaration was done. Even, I dare say, Chief Justice, judges of the Supreme Court, even for the 27 constituency results that were not verbalized. They were not announced verbally, but they were declared because they were posted in the website after chaos broke out at the National Tallying Center. I want to invite the court to consider, in interpreting whether what has been pleaded before this court in terms of what the commission did after that risk on life and limb happened. I want to plead and persuade this court to invoke, by way of analogy, 3 doctrines of law. The first one is the doctrine of frustration in the law of contract, where there are contractual obligations to be performed, but the contract is frustrated. Number 2, the doctrine of necessity in international law. And thirdly and finally, the doctrine of supervening impossibility, where there are legal obligations, but the party on whose those obligations accrue cannot perform them as a result of supervening impossibility. Chief Justice, my lords, my ladies, number 6, the IBC verified and tallied and declared all the results because none of the 46,229 from 34 A's have been impeached. Number 7, the IBC verified, tallied, and declared all the results because the tallying that happens at the National Tallying Center is basically clerical. And I think the commissioner should know none of them, including the chairman, has any role whatsoever that is significant other than just recording the clerical and arithmetical issues. And this is so, and this explains why, even when there are discrepancies between what was transmitted through electronic means and what comes as a physical form, the best that the chairperson, as the returning officer, can do is to note the errors in the error form, and only this court can actually interrogate and decide on the fate of those discrepancies. Number 8, verification, tallying, and declaration was done pursuant to 138.3C and 138.10 because an interpretation in the opposite direction would lead to a constitutional crisis where commissioners who think they have a role to veto and moderate the expression of the will of the people of Kenya in the vote can decide to form factions and have their own candidates, declare their own results, which they have verified in quote and tallied in quotes. Finally, Section 10, 11, and 11A of the Elections Act envisage the commission to include the secretariats and staff, and therefore verification was done according to the affidavit of William Ruto, the affidavit of Veronica Duarte. The tallying was done in the presence of agents at the National Tallying Center. With tremendous respect, I would like to conclude by submitting that this court should find that a petitioner whose agents and supporters are engaged in a kind of behavior that is now of public notoriety, and I invite the court, over and above what is pleaded, to take judicial notice of the events of that day. A petitioner whose supporters, sympathizers, and agents engaged in those kind of things should not be anywhere near the hallowed ground of a Supreme Court of the Republic of Kenya, trying to seek relief, among them a relief under Section 80A, that they be declared winners of an election that they didn't win. we submit that the mob that swelled our image, the image of our nation, including the conductors of the orchestra, are now before this court shouting loudest that we must release Barabbas. This court should stop Barabbas and his mob from benefiting from their own malfeasance. We pray that all the petitions, including the submissions by the Attorney General, particularly on this issue of Article 138, those petitions be struck out with costs. I respectfully and humbly submit